part two of the continuing education for Hawkins Mayor Susan Hubbard and the Hawkins City Council on the Texas Open Meetings Act.
Now, I'm not going to go through all of the many exceptions that exist out there for closed meetings, but I do want to focus on a couple that are broadly applicable and that you may use in your governmental body. The first of those is the attorney consultation exception, and this is probably one of the most often used reasons why people go into closed session. Governmental bodies will often go into closed session to have a private consultation with their attorney. And the provision in the Act allowing these closed sessions provides that a governmental body may not go into closed session with its attorney except when the governmental body seeks the advice of the attorney about pending litigation or contemplated litigation or a settlement offer, or on a matter in which the duty of the attorney to the governmental body under the Texas Disciplinary Rules of Professional Conduct clearly conflicts with the Act. Now, I've quoted this provision directly because it's important to recognize that this exception in the Open Meetings Act is written in the negative, and it is intended to be limited in scope. It does not allow you to have a closed meeting every time your attorney is present. And it doesn't allow you to have a closed meeting every time your attorney is involved in the conversation. It is limited, and you need to make sure that when you go into a closed session under this exception, you qualify under these specific circumstances. There have been a number of cases where governmental bodies have been sued because they go into closed session and then they exceed the scope of this provision.
Oh, shit, that don't sound good for what fucking the Hawkins Mayor and City Council just did and are trying to do.
All right, the next exception for going into closed session that we're going to talk about is deliberations about personnel matters. So governmental bodies are authorized to go into closed session to discuss certain personnel matters. And the Act allows a closed session to deliberate the appointment, employment, evaluation, reassignment, duties, discipline, or dismissal of a public officer or employee, or to hear a complaint or charge against an officer or employee. Now, this exception does not apply if the officer or employee who is the subject of the deliberation or hearing requests a public hearing. It also doesn't apply to the selection of an independent contractor or